Before we begin, a quick and important disclaimer. The information provided in this video is for educational and entertainment purposes only. It does not constitute legal, financial, or psychological advice. Divorce laws vary significantly by state and individual circumstances. You should conduct your own due diligence and consult with a licensed professional in your jurisdiction before making any decisions regarding your personal or legal affairs. Every 60 seconds in the United States, a marriage ends. That is roughly 2,400 divorces a day, nearly 900,000 a year. But there is a silent reality buried beneath these statistics that most men do not realize until it is far too late. By the time you reach the end of this deep dive masterclass, several dozen men across the country will have entered a legal and social machine they fundamentally do not understand. They will walk into a courtroom expecting a logic-based resolution, only to find themselves ensnared in a system built on historical social studies and evolving family policies that often prioritize administrative efficiency over individual fairness. Imagine standing on a bridge that represents everything you have built over the last decade. On one side is your home, your retirement savings, your professional reputation, and your daily relationship with your children. On the other side is a thick, impenetrable fog. For the modern American man, the transition across that bridge is rarely a choice. In fact, historical trends indicate that nearly 80% of divorces in the United States are initiated by women. This is not just a random data point. It is a profound sociological phenomenon that points to a massive disconnect in how men and women experience the American domestic contract. We are witnessing the rise of what social scientists call the divorce industrial complex, a multi-billion-dollar industry where the stakes are your life's work and your legacy. If you feel like the rules of the game changed while you were busy playing it, you are right. This video solves the most critical problem facing men in the American social landscape today: the lack of a comprehensive, objective blueprint for understanding the mechanics of divorce from a social studies perspective. We are going to deconstruct the history of family law, the psychological shifts in domestic policy, and the economic realities of the modern courtroom. By the end of this 10-part series, you will understand the invisible forces at play, from the transition of fault-based divorce to the no-fault era, to the way the best interests of the child standard is actually applied in various jurisdictions. This is not about anger. It is about education. It is about moving from a state of reactive shock to a state of informed awareness. To understand where we are, we have to look at the massive tectonic shift that occurred in the 1970s. Prior to 1969, divorce in the United States was largely fault-based. This meant that to end a marriage, one party had to prove the other had committed a specific legal wrong, such as adultery, abandonment, or extreme cruelty. From a social studies perspective, this created a high barrier to entry for the legal system. It treated marriage as a permanent social contract that could only be broken by a significant breach of terms. However, everything changed when California Governor Ronald Reagan signed the Family Law Act of 1969. This introduced no-fault divorce to the American landscape, and within 15 years, nearly every state followed suit. The introduction of no-fault divorce was a social experiment of unprecedented scale. The intent was to reduce the acrimony of courtroom battles where spouses were forced to manufacture or exaggerate faults to gain their freedom. But the historical trend that followed was something few policymakers predicted. Case studies from the 1970s and 80s show that as the legal barrier to divorce dropped, the rate of initiation surged. For men, this meant the sudden loss of veto power over the dissolution of their family unit. Under the old system, if you were a faithful provider, your spouse could not simply leave and take half the assets without proving you had failed in your marital duties. Under no fault, the social contract of marriage became the only contract in the United States that can be terminated by one party without the other party being in breach, often with significant financial penalties for the non-initiating party. This brings us to the economic reality of the modern American divorce. In our social studies of the domestic unit, we have to look at the concept of community property versus equitable distribution. There are 9 states, including powerhouses like California and Texas, that operate under community property rules. In these jurisdictions, the law generally assumes a 50-50 split of all assets acquired during the marriage, regardless of who earned the money or whose name is on the title. The other 41 states use equitable distribution, which sounds fair on paper, but often leads to more complex and unpredictable outcomes. In an equitable distribution state, a judge has the discretion to divide assets based on what they deem fair, which can be influenced by factors like the length of the marriage, the earning capacity of each spouse, and who will be the primary caregiver for the children. Case studies in high-net-worth divorces often show that men who enter the process without understanding these distinctions end up losing significantly more than the half they were expecting. For example, consider the historical trend of rehabilitative alimony. In the mid-20th century, alimony was often a lifelong pension paid to a former wife who had never worked outside the home. As women entered the workforce in record numbers, social policy shifted. Today, alimony or spousal support is frequently designed to be temporary, intended to allow the lower-earning spouse time to rehabilitate their skills and become self-sufficient. However, the calculation of this support is often based on the standard of living established during the marriage. If you spent 10 years building a lifestyle of luxury, the court's goal is often to maintain that lifestyle for your spouse, even if it means your own standard of living drops by 40 or 50% post-divorce. The social studies of divorce also require a hard look at the tender years doctrine. Historically, in the 19th and early 20th centuries, fathers were actually the preferred custodians of children because they held the economic means to support them. As social norms shifted, the tender years doctrine emerged, suggesting that young children naturally belonged with their mothers. While this doctrine was officially abolished in most states by the late 1970s in favor of the best interests of the child standard, the sociological reality remains complex. Data from the U.S. Census Bureau consistently shows that mothers receive primary physical custody in the vast majority of cases. For the modern man, understanding how to navigate this standard requires a deep dive into how status quo is established in the eyes of the court. If a man moves out of the family home during a separation, often on the advice of a friend or out of a desire to reduce conflict, he may inadvertently be creating a new status quo, where he is merely a visitor in his children's lives. Social studies show that once a routine is established, courts are highly reluctant to change it, as stability is viewed as a primary component of a child's best interest. This is a classic example of how a lack of understanding regarding social policy can lead to a permanent loss of parental rights. We must also address the psychological landscape. American social structures often leave men with smaller social support networks than women. While a woman may have a robust circle of friends and family to lean on during a divorce, many men find that their entire social life was tied to the marriage. When the marriage ends, the man faces not only a legal and financial crisis but a profound social isolation. This isolation gap is a documented historical trend that contributes to the higher rates of post-divorce health issues and career decline among men. This masterclass is designed to fill that gap. We are going to look at the gray divorce phenomenon, the skyrocketing rate of divorce among couples over 50. We will analyze the impact of the 1972 Supreme Court case Stanley v. Illinois, which began the slow process of recognizing the rights of unwed fathers. We will discuss the evolution of Qualified Domestic Relations Orders, or QDROs, and how they allow the court to reach into your 401k or pension. We will even touch on the sociological impact of social media and digital footprints in modern litigation. The goal here is total transparency. You are not just ending a relationship, you are exiting a state-regulated institution. The more you know about the history, the policy, and the data driving that institution, the better positioned you are to navigate it. We are moving beyond the surface-level talk and into the deep mechanics of the American social fabric. This is part 1. We have only just begun to scratch the surface of the history. In the next section, we will break down the specific financial traps that catch 90% of men in the first 30 days of filing. Stay focused. This is the education you were never supposed to have. To understand the first 30 days of a divorce filing, you have to understand that you are not just entering a legal process, you are entering a high-stakes financial audit conducted by the state. Historically, the first month is where the most significant and often irreversible financial errors occur. This period is governed by a set of rules known in many jurisdictions as Automatic Temporary Restraining Orders, or ATROs. While the name sounds aggressive, the intent from a social studies perspective is to maintain the status quo. However, for a man like David, a 42-year-old project manager in Charlotte, North Carolina, in April 2026, the status quo can quickly become a financial prison. Imagine David's situation. He comes home to find he has been served with a summons. In the American legal system of 2026, this summons often carries with it an immediate freeze on all marital assets. David can no longer move money out of his joint savings, he cannot change the beneficiaries on his life insurance or his 401k, and he certainly cannot sell the boat or the second car to fund his legal defense. Historical trends show that men in David's position often react with a sense of panic, leading them to make the first major trap: the voluntary exit from the family home. In the sociological study of domestic litigation, the home is more than just an asset. It is the physical manifestation of the status quo. When David decides to move into a local hotel or a small apartment to give his spouse space and lower the household tension, he is inadvertently signaling to the court that he no longer needs the primary residence. Case studies indicate that once a man moves out, his chances of returning to that home or maintaining a 50-50 custody split of his children drop precipitously. By moving out, David has established a new financial reality. He is now paying for his own separate housing while still being legally obligated to maintain the mortgage, utilities, and upkeep of the family home where he no longer lives. In the social studies of American divorce, this is known as the double housing trap. Step 1 of this 30-day period involves the financial affidavit. In 2026, the level of digital transparency required is unprecedented. David is required to list every single asset, from his primary checking account to his fractional shares in cryptocurrency, and his unused airline miles. The trap here is not just in what you hide, but in how you value what you have. Historical trends suggest that men often overreport their income by failing to account for the fluctuating nature of bonuses or stock options, while simultaneously underreporting their true cost of living. If David states his monthly expenses are $4,000 when they are actually $6,000, the court will base his temporary support obligations on that inaccurate $4,000 figure, leaving David with a permanent monthly deficit. Let us look deeper into the case study of the primary residence in 2026. The American housing market has faced significant volatility over the last few years. If David's home was appraised at $700,000 in 2024 but has dropped to $600,000 by 2026, the timing of the valuation becomes critical. If David agrees to a valuation based on outdated data, he may end up buying out his spouse's share at an inflated price, essentially paying for equity that no longer exists. This is why social studies of divorce emphasize the role of the forensic appraiser. A man who relies on a standards estimate or a friendly real estate agent's opinion is often walking into a trap that can cost him tens of thousands of dollars in the final settlement. Furthermore, we must address the trap of the initial retainer. When David goes to hire a high-profile family law attorney, he is asked for a $10,000 retainer. In his emotional state, he may pull this money from a credit card or a high-interest loan. However, social studies of the legal industry show that initial retainers are often depleted within the first 45 days, due to the heavy administrative lifting of the initial filing. David is now $10,000 in debt with a legal team that is just getting started. Potential outcomes for men who do not budget for a multi-year litigation process often include a total depletion of liquid assets before the case even reaches the settlement conference. Another critical area is the tax implication of the first 30 days. In 2026, the distinction between married filing jointly and married filing separately is more than just a checkbox. If David's divorce is finalized on December 31st, the IRS views him as single for the entire year. However, during the first 30 days of a filing in the middle of the year, David must decide how to handle tax withholdings. If he fails to adjust his W-4 immediately, he may find himself with a massive tax liability at the end of the year, precisely at the moment he needs cash the most. Historical trends indicate that many men overlook the fact that alimony is no longer tax-deductible for the payer at the federal level, a shift that occurred with the Tax Cuts and Jobs Act, and remains a cornerstone of domestic social policy in 2026. Imagine if David also has a significant investment in a 401k or a pension. During the first 30 days, his spouse's attorney will likely file what is known as a joinder, bringing the retirement plan into the lawsuit as a party. This ensures the plan administrator cannot distribute any funds without a court order. David might think his retirement is safe because he earned it through his own labor, but American social studies of property show that any contribution made during the years of marriage is considered marital property. The trap here is the failure to calculate the premarital portion. If David had $100,000 in that account before he got married, and it is now worth $500,000, only the $400,000 gain is subject to division. However, the burden of proof is on David. If he cannot produce the statements from 15 years ago within the first 30 days of discovery, the court may default to treating the entire balance as marital property. This leads us to the psychological economic trap, the scorched earth policy. Case studies from the American Academy of Matrimonial Lawyers show that high-conflict cases often see one party usually the one who feels most aggrieved, attempting to drain the marital estate through excessive litigation. If David's spouse files 25 motions in the first month, David must respond to all of them. Each response costs David 2 to 3 hours of attorney time at $400 an hour. By the end of the first month, David has spent $5,000 just defending himself against procedural motions that have nothing to do with the final outcome. This is the exhaustion strategy, a documented sociological tactic used to force a settlement by making the cost of fighting higher than the cost of surrendering. The step-by-step reality of the first 30 days is a transition from being a partner to being a defendant in a civil suit. It requires a shift in mindset from emotional processing to data management. David needs to secure his personal data, change his passwords, and begin a meticulous log of every interaction and every expense. Potential outcomes for those who remain in an emotional fog during this window are often characterized by a loss of leverage that takes years to recover, if it can be recovered at all. As we conclude this deep dive into the financial traps of the first 30 days, we must prepare for the next layer of this social study. While the money is the foundation, the true battlefield of the American divorce is often found in the psychological warfare of the custody battle and the manipulation of social narratives. What happens when the person who knows you best becomes the person most incentivized to misrepresent you to the state? In Part 3, we will break down the sociological mechanics of the silver bullet strategy and how the best interests of the child standard is often used as a weapon of financial and emotional leverage. The window for protecting your legacy is closing faster than you think. Stay with us as we go even deeper into the masterclass. In the American social studies of domestic litigation, there is perhaps no phrase more widely misunderstood than the best interests of the child. While it sounds like a definitive, objective standard, historical trends indicate it is one of the most subjective and strategically manipulated concepts in the modern courtroom. By 2026, the application of this standard has evolved into a complex sociological tug-of-war where the prize is not just time with your children, but the very definition of your character. To understand how this works, we have to look at the transition from the tender years doctrine to the modern gender-neutral statutes, and the reality of how these laws are executed on the ground in high-conflict scenarios. Imagine a character named James, a 45-year-old software architect living in suburban Illinois in 2026. James has spent the last decade building a successful career, often working late or traveling for conferences to ensure his family has a high standard of living. In his mind, he is providing for his children. However, in the social study of a divorce filing, that same provider role is often flipped to characterize James as an absentee parent. When the divorce is initiated, the first move in the sociological playbook is often to establish a status quo that limits the father's access. If James is served with papers on a Tuesday and told he needs to move out or is restricted to seeing his children every other weekend, he is entering a cycle that social scientists call the primary parent trap. The first step in this process is the temporary orders hearing. In many jurisdictions, this hearing happens within the first few weeks of a filing and sets the tone for the entire case. Potential outcomes for men like James often depend on how the concept of the primary caregiver is defined. If his spouse has traditionally handled school registrations, doctor appointments, and extracurricular sign-ups, the court may view her as the psychological parent. From a social studies perspective, this creates a hierarchy where one parent is the manager and the other is the assistant. James may find that his decade of financial provision is viewed as secondary to the administrative tasks of parenting. To counter this, historical trends suggest that men must demonstrate an immediate and proactive shift into the administrative side of parenting, showing up to every game, communicating directly with teachers, and documenting their daily involvement, long before they ever step into a courtroom. We must now address the sociological phenomenon often referred to in case studies as the silver bullet. This is a strategic maneuver where one party makes an allegation of domestic instability or safety concerns to secure an immediate, ex parte restraining order. In the social fabric of 2026, the mere allegation can trigger a total lockdown of a father's access to his home and his children before a single piece of evidence is presented. While these laws are designed to protect truly vulnerable individuals, sociological data shows they are frequently used as a tactical entry point into a custody battle. For James, a silver bullet allegation means he is suddenly fighting from a position of deficit. He is no longer fighting for 50-50 custody. He is fighting to prove he is not a danger. The historical trend here is clear. Once a father is removed from the home under a temporary order, it can take 6 months to a year of expensive litigation just to return to the starting line of supervised visitation. This leads to the appointment of a guardian ad litem, or a custody evaluator. In the social studies of American law, these individuals are tasked with being the eyes and ears of the court. However, they are human beings with their own sociological biases. A case study of a typical evaluation in 2026 involves multiple home visits, psychological testing, and interviews with third parties like teachers and neighbors. James must understand that every interaction with the guardian ad litem is a high-stakes interview. If he expresses anger about the divorce process, he may be labeled as high conflict. If he is too passive, he may be seen as uninterested. The step-by-step reality of an evaluation requires a level of emotional regulation that is incredibly difficult to maintain during the dissolution of one's family. Furthermore, we must examine the intersection of custody and the financial social contract. In nearly every U.S. state, child support is calculated based on a formula that includes the number of overnights each parent has. This creates a powerful state-sanctioned financial incentive to fight for more time. From a social studies perspective, we see that custody battles are often less about the child's well-being and more about the shifting of wealth. If James's spouse can secure 65% of the overnights, she may also secure a significant monthly transfer of James's income for the next decade. This is why the fight for 50-50 custody is often so visceral. It is the difference between a sustainable post-divorce life and a state of permanent financial struggle. In 2026, we also see the rise of parental alienation as a recognized sociological phenomenon. This is the process where one parent systematically demeans the other parent to the child, effectively destroying the child's relationship with that parent. Case studies show that this is rarely an overnight event. It is a slow erosion. It starts with small comments about why dad is late, or how dad's new apartment is too small. Over time, the child begins to mirror the alienating parent's hostility. For the modern man, identifying and documenting these patterns is critical. The historical trend in social studies indicates that courts are becoming more aware of alienation, but the burden of proof is exceptionally high and usually requires expensive forensic psychological experts to diagnose. Imagine if James decides to fight for his right to be an equal parent. He will likely face the psychological pressure of the best interest standard being used to shame him. He might be told that a 50-50 split is too hard on the children or that they need a primary home base for stability. Yet, modern social studies research consistently shows that children with two actively involved parents have better long-term outcomes in education, mental health, and social stability. The disconnect between what the data says and what the courtroom does is the primary hurdle for men in the American social landscape today. To navigate this, a man must become a historian of his own life. He must move beyond the emotional pain and start collecting data. Who takes the child to the dentist? Who helps with the science project? Who knows the names of the child's friends? In the social study of a custody battle, the parent who has the best data often has the best potential outcome. This is not about being a better parent in your heart. It is about proving it on a spreadsheet. As we conclude this deep dive into the sociological warfare of custody and the best interest standard, we have to prepare for the next phase of the masterclass. While the children and the money are the primary stakes, the mechanism that determines the outcome is the process of discovery. What happens when your entire digital life, every text message, every bank statement, every social media post, is turned over to a hostile legal team? In Part 4, we will break down the mechanics of the digital dragnet and how your history from 2020 to 2026 is being analyzed right now to build a case against you. The walls have ears, and in the modern divorce they have a permanent memory. Stay with us as we reveal the hidden dangers of the discovery phase. The discovery phase is the engine room of the American legal system, and in 2026, it has become a digital dragnet of staggering proportions. Many men enter this stage believing their private conversations, deleted search histories, and personal financial apps are shielded by a wall of privacy. The reality, as dictated by modern social studies of family law, is that once a petition for dissolution is filed, your life becomes an open book. Discovery is the formal process of exchanging information between parties, but in practice, it is an exhaustive data mining operation designed to find inconsistencies that can be used to leverage a settlement or impeach your credibility in front of a judge. Let us look at the case study of Robert, a 38-year-old marketing director in Austin, Texas. Robert is a typical professional in 2026. His entire life is synced to the cloud. When he receives the first set of discovery requests, he is confronted with three primary tools: interrogatories, requests for production of documents, and requests for admissions. From a sociological perspective, these tools are designed to strip away the curated persona Robert has built and reveal the underlying raw data of his life. The interrogatories are a set of written questions that Robert must answer under oath. In 2026, these are no longer just basic questions about his name and address. They are sophisticated inquiries into his lifestyle. For example, one question might ask him to list every vacation he has taken in the last 5 years, including the cost and the source of the funds. If Robert spent $10,000 on a trip to Tulum in 2025 while claiming he could not afford to contribute more to the family savings, that answer becomes a permanent record of lifestyle inconsistency. Historical trends show that men often treat these questions casually, failing to realize that every word is a potential landmine. Next comes the request for production of documents. This is where the digital dragnet tightens. In the social studies of modern divorce, the document request is the most labor-intensive and invasive part of the process. Robert is required to produce at least 3 years of bank statements, credit card statements, tax returns, and pay stubs. But in 2026, the net goes much deeper. It now includes his Venmo and Zelle history, his cryptocurrency wallet addresses, and his Amazon purchase history. Imagine if Robert has a side hustle or a hobby that involves cash or digital transfers. If his Venmo history shows dozens of payments labeled for things like fantasy football or weekend outings that do not appear on his official financial affidavit, he is opening himself up to a charge of dissipation of marital assets. Dissipation is a legal concept where one spouse is accused of wasting marital funds for non-marital purposes. In a social studies context, this is often used to balance the scales of asset division. If Robert is found to have dissipated $50,000 on personal luxuries over the last 3 years, the court may award his spouse an extra $50,000 from the remaining house equity to compensate. The most dangerous part of the production phase in 2026 is the metadata. Every photo Robert has taken, every text he has sent, and every location he has visited is tagged with time and GPS coordinates. If Robert told the court he was working late on a Tuesday, but his Google Maps timeline shows he was at a sports bar across town, his credibility is effectively destroyed. Forensic experts can now use AI-driven software to cross-reference multiple data points. They can match a credit card charge at a restaurant with a calendar invite and a social media post from a third party to reconstruct Robert's exact movements. Case studies indicate that men who attempt to hide their tracks often forget about the interconnectivity of the modern Internet of Things. Even his smart home thermostat or his Tesla's driving logs can be subpoenaed to prove when he was home and when he was not. Then we have the requests for admissions. These are simple statements that Robert must either admit or deny. For instance, admit or deny that you transferred $5,000 to your brother's bank account in January 2026. If Robert denies a statement that is later proven true through document production, he may face significant sanctions, including having to pay the other side's legal fees for the time spent proving the fact. This is the psychological pressure of the discovery phase. It forces a man to confront the reality of his own data before he ever speaks a word in court. Step by step, the discovery process follows a strict timeline. Usually, Robert has 30 days to respond to the initial requests. During this time, he and his legal team must create what is known as a privilege log. This is a list of documents that are being withheld because they are protected by attorney-client privilege. However, historical trends show that men often over-rely on privilege, failing to realize that bank records and text messages to friends are almost never privileged. The organizational burden is immense. Robert must gather thousands of pages of data, ensure they are formatted correctly, and verify that nothing is missing. A single missing bank statement can lead to a motion to compel, which adds thousands of dollars in unnecessary legal fees. Finally, we must discuss the deposition. This is the trial before the trial. It is a face-to-face interrogation where Robert sits in a conference room, or more likely a Zoom call in 2026, and answers questions from his spouse's attorney for up to 7 hours. A court reporter records every word. In the sociological study of legal conflict, the deposition is designed to wear a person down. The goal is to get Robert to make a statement that contradicts his written interrogatories or his produced documents. Case studies of deposition show that the most successful outcomes for men occur when they understand the rule of box 1 versus box 2. Box 1 is a direct, honest answer to the question asked. Box 2 is the unnecessary explanation, the justification, or the emotional venting that men often feel the need to provide. If the attorney asks, "Did you withdraw $1,000 on June 12th? The box 1 answer is yes. The box 2 answer is, "Yes, but I only did it because she was spending all the money on clothes and I needed to pay the rent." By moving into box 2, Robert has just given the opposing counsel 3 new avenues of questioning. He has effectively handed them the map to his next hour of interrogation. The discovery phase is not just about facts. It is about building a narrative of character. In the American social landscape, the man who is organized, transparent, and disciplined in his data management is the man who survives the dragnet. The man who is reactive, secretive, or disorganized often finds himself buried under a mountain of his own digital history. But what happens once all this data is gathered? What happens when the discovery is complete and the case moves into the shadow of the courthouse? In Part 5, we are going to explore the high-stakes world of mediation and the settlement industrial complex. We will look at why 95% of cases never go to trial and the invisible social pressures used to force men into signing agreements they will regret for the rest of their lives. We will break down the exact tactics used by mediators to split the difference at your expense. The real negotiation is about to begin. Stay tuned for the deep dive into the art of the settlement. Mediation is not a search for justice. It is a search for a signature. In the American social studies of domestic law, mediation has evolved from an optional alternative into a mandatory gateway. By 2026, nearly every jurisdiction in the United States requires parties to attempt at least one full day of mediation before they are even allowed to request a trial date. This creates a massive sociological bottleneck, known as the settlement industrial complex. The system is designed with a singular goal: to remove your case from the public docket to save the state time and money. For the modern man, this means entering a high-pressure environment where the social contract of your marriage is boiled down to a series of rapid-fire compromises. Imagine Michael, a 50-year-old logistics manager in Columbus, Ohio. In the summer of 2026, Michael has spent over $30,000 on legal fees over the last 18 months. He is emotionally drained and financially stretched. He enters a mediation suite, or in the 2026 landscape, a secure virtual breakout room, expecting a neutral third party to look at the facts and suggest a fair outcome. What Michael actually encounters is the tactical use of shuttle diplomacy. This is a sociological maneuver where the mediator keeps the parties in separate rooms and acts as the sole conduit of information. By controlling the narrative in each room, the mediator can amplify the fears of both sides to drive them toward a middle ground. The first tactical maneuver Michael faces is the sunk cost fallacy. The mediator, often a retired judge or a senior attorney with decades of experience in the social study of family dynamics, will spend the first 2 hours highlighting the astronomical costs of going to trial. They will point out that Michael has already spent $30,000, and that a trial will likely cost him another $50,000 with no assurance of the outcome. Historical trends suggest that this is the moment many men begin to fold. They start viewing the settlement not through the lens of what is right, but through the lens of stopping the financial bleeding. This is a documented psychological state where the desire for relief outweighs the long-term economic impact of the deal being offered. Next comes the anchor effect. This is a common tactic in the social studies of negotiation. Michael's spouse may start with an extreme demand, perhaps 80% of the home equity and lifetime alimony. Even though this demand is statistically unlikely to be granted by a judge, it serves as an anchor. The mediator then works to move the parties off their anchors. If the mediator moves the spouse down to 60%, it feels like a victory for Michael, even if the fair distribution under equitable distribution laws should have been closer to 50%. By starting at an extreme, the spouse has defined the range of the conversation. Potential outcomes for men who do not understand anchoring often involve them agreeing to a deal that is still significantly worse than the statistical average for their jurisdiction, simply because it feels better than the initial extreme demand. Step by step, the mediation process is designed to induce decision fatigue. A standard mediation session in 2026 can last anywhere from 8 to 12 hours. Sociological research on human performance indicates that our ability to make complex financial decisions degrades significantly after the 4-hour mark. By hour 8, Michael is hungry, exhausted, and desperate for the conflict to end. This is known as the Friday afternoon effect. Mediators know that as the clock ticks toward the end of the day, parties are more likely to concede on major points just to achieve finality. Michael might agree to a non-modifiable alimony provision or a restrictive right of first refusal regarding his children that he would have never accepted at 9 in the morning. We must also look at the language of the Memorandum of Understanding, or the MOU. This is the document signed at the end of a successful mediation. In the social studies of American law, the MOU is often considered a binding contract the moment the ink dries. Men like Michael often sign these documents believing they are just an outline that their attorney will fix later. However, case studies show that it is incredibly difficult to change the terms of an MOU once it is signed. If Michael agrees to pay a specific dollar amount in child support that exceeds the state guidelines, and he signs that MOU, he may be stuck with that obligation for years, regardless of future changes in his income. The sociological pressure to sign is immense. The mediator may even tell Michael that if he does not sign today, the entire deal is off the table and they are going to trial. Imagine if Michael is presented with the choice between a larger share of his retirement account or keeping the family home. In the social studies of finance, these two assets are often treated as equal in value on a balance sheet, but their real-world utility is vastly different. A $401,000 is not the same as $400,000 in home equity. The 401k carries a future tax liability and is illiquid, while the home equity is a primary residence that provides stability and potential tax-free gains. Historical trends indicate that men often trade liquid or high-utility assets for future retirement points because they are focused on the total number, rather than the asset class. This is the valuation trap of mediation. Furthermore, mediation often introduces social engineering clauses that can haunt a man for a decade. One such clause is the morality clause, which in 2026 has seen a resurgence in certain regions. This clause might prohibit Michael from having a romantic partner stay overnight while the children are present. While it sounds reasonable in a sterile conference room, the sociological impact on Michael's ability to move on with his life and form a new family unit is profound. Another is the right of first refusal, which requires Michael to call his ex-spouse if he needs a babysitter for more than 4 hours. In practice, this often becomes a tool for micromanagement and continued conflict, yet it is frequently pushed in mediation as a child-centric compromise. The reality of the settlement industrial complex is that it prioritizes the closing of the file over the health of the post-divorce family. Michael leaves the room feeling a sense of relief that the litigation is over, but within 48 hours, the buyer's remorse sets in. He realizes he has traded away his future mobility or his financial surplus for a peace that feels increasingly hollow. The social study of these settlements shows a high rate of post-judgment litigation, as men realize the terms they agreed to under the pressure of mediation are unsustainable in the real world. But what if you refuse to sign? What if you are one of the 5% who pushes past the mediation trap and insists on your day in court? The American social landscape changes entirely when you move from the conference room to the courtroom. In Part 6, we are going to dive into the architecture of the trial. We will look at the sociological theater of the witness stand, the impact of judicial bias in 2026, and the specific ways evidence is admitted or excluded to shape the court's perception of who you are as a man and a father. The stakes are about to shift from a negotiation to a judgment. Prepare yourself for the reality of the courtroom floor. The trial is the ultimate sociological theater of the American legal system. In the social studies of domestic relations, we often call this the stage of last resort. By 2026, most men have been conditioned to believe that a trial is a search for the objective truth, much like a scientific experiment. However, the reality of the American family court is that it is a court of equity, not a court of law. This distinction is critical. In a court of law, specific rules are applied to facts to reach a conclusion. In a court of equity, a single individual, the judge, has broad, almost unilateral discretion to decide what is fair based on their interpretation of the social fabric of your family. There is no jury of your peers here. There is only one person whose personal biases, historical perspectives, and even their mood on a Tuesday morning in 2026 will determine the trajectory of your next 20 years. Imagine Christopher, a 44-year-old civil engineer in Richmond, Virginia. After 18 months of failed mediation and exhaustive discovery, Christopher finds himself sitting at the petitioner's table. He has spent over $75,000 to get to this moment. The room is silent except for the humming of the digital recording equipment and the rustle of papers. Christopher expects to present his spreadsheets, his detailed logs of every soccer practice he attended, and his clean financial records. But as the trial begins, he realizes that the court is not looking for a data point. It is looking for a narrative. The first concept Christopher must navigate is judicial discretion. In the social studies of the U.S. judiciary, this is the power of a judge to make decisions based on their own judgment rather than a strict legal requirement. Case studies show that two different judges in the same courthouse can look at the exact same set of facts and reach diametrically opposed conclusions. One judge might value the historical trend of the primary caregiver and award the spouse 70% of the time. Another judge might value the modern social movement toward equal shared parenting and order a strict week-on, week-off schedule. Christopher is not just fighting his spouse, he is navigating the ideological landscape of the person on the bench. Next comes the rules of evidence, which in 2026 have become increasingly complex due to the saturation of digital data. Christopher's attorney attempts to enter a series of text messages into the record to prove a pattern of parental alienation. However, the opposing counsel objects on the grounds of hearsay or lack of foundation. In the sociological study of the courtroom, evidence is not just what happened. It is what can be legally admitted. If Christopher did not preserve the metadata or if he cannot prove the chain of custody for those digital files, his most powerful evidence might be ruled inadmissible. Step by step, Christopher watches as the reality he lived for a decade is filtered through the narrow lens of the rules of evidence, until only a fragmented version remains. Then there is the witness stand. For a man in 2026, the witness stand is an exercise in extreme emotional regulation. Imagine if Christopher is asked about a heated argument from 3 years ago. The opposing attorney is not looking for an explanation, they are looking for a reaction. If Christopher becomes defensive, he fits the social stereotype of the angry male. If he is too cold, he is labeled as emotionally unavailable. Historical trends in family law indicate that the perception of a father's temperament often carries more weight than his actual parenting ability. Christopher must answer questions that are designed to trap him into contradictions. This is the cross-examination, a tactical maneuver intended to impeach his character. Consider the role of the expert witness. In a 2026 high-conflict trial, the judge often relies on a court-appointed psychologist or a forensic accountant to provide a scientific veneer to the proceedings. Christopher has to pay for half of these experts, even if their reports are unfavorable to him. A custody evaluator might testify that while Christopher is a competent parent, the children's social development is better served by remaining in the primary residence with the mother to maintain their current school district and social circle. From a social studies perspective, this is the application of the stability factor, a historical preference that often penalizes the parent who has moved out of the home, even if that move was intended to reduce conflict. Furthermore, the trial introduces the concept of the preponderance of the evidence. Unlike a criminal trial where the standard is beyond a reasonable doubt, a family court judge only needs to believe that something is 51% likely to be true. This lower threshold makes the trial a game of margins. If Christopher's spouse can create a narrative that he prioritized his career over his children by just a few percentage points of probability, the judge may find in her favor on the issue of primary physical custody. The sociological impact of this lower standard is that it encourages the dredging up of every minor mistake, every late arrival, and every forgotten school lunch from the last 10 years. Step by step, the trial moves from opening statements to the presentation of evidence, the testimony of witnesses, and finally, the closing arguments. For Christopher, the process is exhausting. He is hearing his life story told back to him by strangers who have never met his children. He sees his financial life dismantled by a forensic accountant who treats his life's work as a series of line items on a balance sheet. The trial is not a resolution. It is a clinical dissection of a human relationship. In 2026, we also see the rise of the hybrid trial. Christopher might be in a physical courtroom, while his spouse's expert witness testifies via a high-definition video link from another state. The sociological effect of this technology is a subtle distancing. It is easier to be clinical and detached when the person you are testifying against is a face on a screen. Yet, for Christopher, the consequences are anything but detached. The final judgment, once signed, becomes a state-enforced mandate. It dictates where he can live, how much of his paycheck he keeps, and when he is allowed to see his children. Potential outcomes after a trial often include a sense of total loss of agency. Even if Christopher wins on several points, he has ceded the ultimate control of his life to the state. But the trial is only the end of the beginning. Once the judge issues the final order, a new and perhaps even more complex social dynamic begins. The era of post-judgment life. What happens when the court order meets the messy reality of 2026? What happens when the financial obligations you agreed to or were ordered to pay become impossible to meet due to economic shifts? In Part 7, we are going to explore the world of enforcement and modification. We will look at the sociological mechanics of the contempt of court process and how the state uses its police power to enforce the domestic social contract. We will also break down the specific criteria needed to modify an order when your life inevitably changes. The ink is dry, but the struggle for autonomy is just entering a new phase. Stay tuned for the deep dive into the reality of life under a court order. Life under a court order in 2026 is not merely a set of rules. It is a continuous state of supervision by the administrative machinery of the government. Many men believe that once the final decree is signed, the legal battle is over, and they can return to a semblance of a normal, autonomous life. However, from a social studies perspective, the final decree is actually the beginning of a new state-mandated relationship. You have transitioned from a private citizen in a domestic partnership to a regulated entity under the jurisdiction of the Court of Equity. This is the era of enforcement and modification, where every change in your life, from a promotion to a medical emergency, must be filtered through a legal lens. Imagine Brandon, a 48-year-old senior systems architect living in San Jose, California, in June 2026. Brandon's divorce was finalized in early 2025. He has a court-ordered child support obligation of $3,000 a month and a rigid visitation schedule. In the volatile economic landscape of 2026, Brandon's company undergoes a massive restructuring due to advancements in autonomous infrastructure, and his position is eliminated. Suddenly, the $3,000 obligation that was manageable at a $200,000 salary becomes a crushing weight on his dwindling severance. The first sociological trap Brandon encounters is the modification threshold. In American social studies of family law, you cannot simply stop paying or reduce your payments because your circumstances have changed. You must prove a substantial and material change in circumstances. Brandon might think that losing his job is the definition of a substantial change, but historical trends indicate that the court's primary concern is not Brandon's financial survival, but the maintenance of the child's standard of living. Step by step, Brandon must file a formal motion to modify support. Until that motion is filed and served, his $3,000 obligation continues to accrue every single month. This is known as the rule against retroactive modification. If Brandon waits 3 months to find a lawyer and file the paperwork, he is legally on the hook for $9,000 that a judge cannot waive, even if they eventually lower his future payments. Furthermore, Brandon faces the concept of imputed income. If the court determines that Brandon is underemployed, meaning he has the skills to earn $200,000 but has taken a lower-paying job to reduce his stress, the judge can order him to pay support based on what he could be earning, not what he is actually earning. In the social studies of 2026, we see this frequently as men attempt to pivot careers post-divorce. The state effectively dictates your career path by locking you into your highest historical earning capacity. Potential outcomes for men who cannot find a comparable salary often involve a rapid accumulation of arrears, which carry high interest rates, in some states as high as 10% annually. Now, let us look at the enforcement side of the equation through the lens of Title 4D of the Social Security Act. This is a federal-state partnership that turned child support into a high-tech debt collection system. If Brandon misses a payment, he is no longer just dealing with his ex-spouse. He is dealing with the state disbursement unit. In 2026, this system is almost entirely automated. By the time Brandon is 30 days late, a series of administrative triggers are pulled. His driver's license can be suspended. His passport can be revoked. His professional engineering license can be placed on hold. In the social studies of American governance, this is a unique use of police power. The state removes your ability to work and travel as a method of coercing payment for a civil debt. Imagine if Brandon, frustrated by his financial situation and the fact that his ex-spouse is refusing to let him see the children on his scheduled weekends, decides to withhold a payment as leverage. This is the most dangerous tactical error a man can make in the 2026 legal landscape. From a social studies perspective, the American legal system treats support and visitation as two entirely separate silos. If the ex-spouse denies visitation, she is in contempt of the parenting plan. If Brandon withholds support, he is in contempt of the financial order. Case studies show that judges are far more likely to punish a father for missing a payment than they are to punish a mother for missing a visitation weekend. If Brandon walks into court and says he stopped paying because he wasn't seeing his kids, he has just handed the judge a confession of contempt. This brings us to the mechanics of a contempt of court filing. There are two types: civil and criminal. Civil contempt is designed to coerce compliance. You have the keys to your own jail cell. meaning if you pay the purge amount, you are released. Criminal contempt is designed to punish a past violation. In 2026, the threshold for a contempt finding is whether you had the ability to comply. Brandon must prove a negative, that he absolutely did not have the funds to pay. However, the state's definition of ability to pay is broad. If Brandon has a retirement account, a car with equity, or even a supportive family who could lend him money, the court may find that he had the ability to pay and simply chose not to. Step by step, the enforcement process is relentless. If Brandon's arrears reach a certain threshold, the state can intercept his tax refunds, place a lien on his home, and even seize his bank accounts through an administrative levy without a hearing. This is the sociological reality of the post-judgment world. You are living in a transparent financial box where the state has a master key. But what about the visitation side? Imagine if Brandon's ex-spouse decides to relocate the children 500 miles away for a new job opportunity. This is the move-away case, one of the most litigated areas of social studies in family law. In 2026, with the rise of remote work, relocation disputes have skyrocketed. Brandon must now fight a second trial to prevent the relocation. The court will look at the reason for the move, the impact on the children's relationship with Brandon, and whether the move will improve the children's quality of life. Historical trends show that if the moving parent can prove a significant economic benefit to the children, the move is often granted, effectively turning Brandon into a long-distance, Zoom-based father. This constant threat of litigation and enforcement creates a state of perpetual hypervigilance. Brandon must document every exchange, keep every receipt, and maintain a meticulous calendar. One missed pickup or one late payment can trigger a new round of legal fees and emotional turmoil. The sociological impact on men's mental health in this post-judgment phase is a growing area of study, as the finality of the divorce proves to be an illusion. You are not just co-parenting. You are co-litigating the remainder of your children's minority. As we navigate the complexities of life under a court order, we must also recognize that the battle for your reputation and social standing is happening simultaneously. While the court order governs your legal life, the social narrative of your divorce is being written in the court of public opinion and across the digital landscape. What happens when your private struggle becomes public? What happens when your career, your social circle, and your digital footprint are weaponized against you in the era of cancel culture? In Part 8, we are going to dive into the sociological world of reputation management and digital warfare. We will look at how to protect your professional identity and navigate the social fallout of a high-conflict divorce in a world that never forgets. The legal battle is only half the story. The battle for your name is next. Stay tuned for the masterclass deep dive into social survival. The legal battle takes place within the four walls of a courtroom, but the social battle takes place in the infinite space of the digital ether. In the American Social Studies of 2026, your reputation is not just a vague concept of character, it is a measurable asset, often referred to by sociologists as social capital. For a man, the dissolution of a marriage frequently triggers a rapid devaluation of this capital. The transition from a stable family man to a single litigating individual can be weaponized by a strategic opponent to erode your professional standing, your community ties, and your psychological well-being. This is the era of digital warfare, where the screenshot is the primary weapon and the social feed is the primary battlefield. Imagine Marcus, a 46-year-old vice president of engineering at a renewable energy firm in Seattle, Washington. It is October 2026. Marcus has spent 20 years building a reputation for reliability, leadership, and integrity. However, as his divorce enters its second year, he finds that the narrative of his life is being rewritten in real time. This is the sociological phenomenon of character assassination, a strategic attempt to destroy a person's reputation through the use of curated half-truths, out-of-context digital evidence, and social engineering. The first front in this war is the digital footprint. In 2026, social studies of legal trends show that nearly 90% of domestic cases involve some form of social media evidence. Marcus might think that because he has blocked his spouse or set his profile to private, he is safe. However, historical trends indicate that the digital dragnet is far more pervasive. Opposing counsel often employs digital forensic specialists or simply utilizes mutual friends, willingly or unwillingly, to act as data harvesters. A photo of Marcus at a professional dinner where alcohol is served can be cropped and recontextualized as evidence of a substance abuse problem. A venting text message sent to a brother in a moment of frustration becomes a permanent exhibit, A used to prove a volatile temperament. Step by step, the destruction of social capital often follows a predictable pattern. It begins with the cryptic post. In 2026, with the help of AI-driven content generation, a spouse can craft narratives that imply victimhood without making specific, actionable allegations. These posts are designed to trigger the observer's protective instincts. Sociological data suggests that when a social circle is presented with a vague narrative of domestic struggle, there is a historical trend for individuals to default to a side before all facts are known. For Marcus, this means walking into his local gym or his children's school and feeling a palpable shift in the atmosphere. He is being tried in the court of public opinion without ever knowing the charges. Furthermore, we must address the professional fallout. In the corporate landscape of 2026, many high-level employment contracts include morality or reputation clauses. These clauses state that any behavior that brings disrepute to the company is grounds for termination or a reduction in bonuses. Marcus finds himself in a situation where his HR department receives an anonymous tip, or perhaps a direct message, containing screenshots of his divorce filings or allegations of financial impropriety. Even if the allegations are proven false in a court of law a year later, the immediate potential outcomes often include a loss of promotion opportunities, exclusion from key projects, and a permanent stain on his professional dossier. The company, seeking to mitigate risk in a sensitive social environment, may decide that Marcus is simply too much of a liability. The sociological study of social circles during a divorce reveals the phenomenon of the fractured network. Imagine if Marcus and his spouse shared a tight-knit group of friends for 15 years. When the divorce begins, this network rarely stays neutral. Instead, it splits. This is often driven by the information gap. The spouse who initiates the divorce usually has a multi-month head start in crafting their narrative. By the time Marcus even realizes he is in a battle, his social circle has already been briefed on a specific version of the story. Case studies show that men often react by withdrawing, which only reinforces the narrative that they are the guilty party. The silence of the man is frequently misinterpreted as shame or admission of guilt. In 2026, we also see the rise of the digital archive. Sites and services now exist that allow users to archive an entire person's social media history before they have a chance to delete it. Even if Marcus realizes his mistake and scrubs his digital presence, the archive already exists in a searchable format for opposing counsel. Potential outcomes for men who engage in online arguments or attempt to defend themselves in public forums are almost universally negative. From a social studies perspective, the more a man tries to publicly defend his character, the more he appears to be in a state of crisis, which paradoxically devalues his reputation further. Step by step, reputation management in 2026 requires a level of discipline that is antithetical to human emotion. It requires the gray rock method, a sociological tactic where a person becomes as uninteresting and non-responsive as a gray rock. By refusing to provide new data points for the narrative, Marcus can eventually starve the smear campaign of its oxygen. However, this requires him to ignore public provocations, stay off social media entirely, and maintain a professional persona that is beyond reproach. Historical trends suggest that the most successful outcomes for men in Marcus's position are achieved by those who treat their reputation as a long-term investment rather than a short-term battle. Consider the impact on the family legacy. In the social study of American domesticity, the father's reputation is often the cornerstone of the children's social standing. If Marcus's name is dragged through the digital mud, his children bear the weight of that narrative in their own social spheres. This is the multi-generational impact of reputation warfare. It is not just about Marcus's job or his friends. It is about the story his children will tell about their father 10 years from now. Imagine if Marcus decides to fight fire with fire. He begins posting his own counter-narratives, sharing evidence of his spouse's failings. Sociologically, this creates a race to the bottom known as mutual assured destruction. In the eyes of the court and the community, both parties are now viewed as equally toxic. The nuanced facts are lost in the noise of the conflict. The potential outcome is a permanent loss of social standing for the entire family unit. As we conclude this exploration of the digital battlefield and the destruction of social capital, we must recognize that the end of the divorce is not the end of the process. Even after the decree is signed and the reputation is managed, there is a profound psychological and sociological vacuum that remains. What happens when the dust settles and you are left standing in the ruins of your old life? How do you rebuild a sense of self and a vision for the future in a landscape that has been fundamentally altered? In Part 9, we are going to dive into the deep psychological social study of rebuilding and post-traumatic growth. We will look at the data on male recovery, the evolution of the new family dynamic, and the specific strategies used by men to regain their autonomy and purpose in the years following a total domestic collapse. The reconstruction is the hardest part. Stay with us for the penultimate chapter of the masterclass. Rebuilding after a total domestic collapse is not about returning to the person you were before the filing. It is about the architectural reconstruction of a new identity in a landscape that has been permanently altered. In the social studies of male recovery post-divorce, we often identify a period known as the identity vacuum. For many American men in 2026, their sense of self is traditionally tethered to their roles as a provider, a protector, and a husband. When the legal system effectively strip-mines these roles, the resulting psychological void can be catastrophic. Historical trends indicate that men who fail to navigate this vacuum effectively are at a significantly higher risk for long-term social isolation and health decline. To move from the wreckage to reconstruction, one must understand the data-driven phases of post-traumatic growth. Imagine Kevin, a 40-year-old pharmaceutical sales executive in Indianapolis, Indiana. It is November 2026. Kevin has spent the last 2 years in a high-conflict litigation battle that ended with he and his spouse selling the family home and dividing their assets 60-40 in her favor. Kevin now sits in a 2-bedroom apartment that feels more like a waiting room than a home. In the sociological study of post-divorce life, this is the ground zero phase. Kevin is experiencing what researchers call the cortisol wall. For years, his body has been flooded with stress hormones. Now that the legal pressure has subsided, his system is crashing. Case studies show that this is the moment many men turn to maladaptive coping mechanisms, overwork, substance use, or premature re-entry into the dating market, to fill the silence. The first step in the reconstruction process is the stabilization of the physical environment. In the social studies of domesticity, the home is a psychological anchor. Men like Kevin often fall into the trap of living in a state of temporary transience, keeping their belongings in boxes and refusing to invest in their new space because it feels like a step down. However, potential outcomes for men who lean into their new environment are significantly better. This involves a deliberate act of domestic agency, setting up a dedicated space for the children, establishing new routines that are independent of the old marriage, and reclaiming the home as a place of peace, rather than a reminder of loss. Step by step, Kevin must move from a survivalist mindset to a curator mindset. Next, we must analyze the shift in the parenting dynamic. In 2026, the American social landscape is moving away from the ideal of the high-collaboration co-parenting model in high-conflict cases, moving instead toward parallel parenting. Historical trends suggest that for men who have dealt with high levels of conflict or alienation, trying to co-parent, which requires frequent communication and shared decision-making, often leads to continued legal skirmishes and emotional exhaustion. Parallel parenting allows each parent to operate independently within their own home. Kevin does not need to know what his children are eating for dinner at their mother's house, and she does not need to dictate his bedtimes. By creating a boundary that limits communication to a shared digital calendar or a parenting app, Kevin reduces the surface area for conflict. This sociological boundary is the foundation upon which he can rebuild his relationship with his children as an autonomous father. Furthermore, the economic reset of 2026 requires a cold, analytical look at the remaining social and financial capital. Kevin's wealth has been halved, but his earning potential remains. In the social studies of male recovery, we see the rise of the second career phase. This is not necessarily a change in jobs, but a change in the purpose of work. No longer working to fund a domestic contract that has been dissolved, men often find a new sense of drive in building a legacy that is purely theirs, or in pursuing professional milestones they previously sidelined for the sake of marital harmony. However, the trap here is the hedonic treadmill. If Kevin spends his energy trying to quickly regain his pre-divorce net worth through high-risk investments or extreme overwork, he may inadvertently sabotage his long-term health and his relationship with his children. Historical trends indicate that financial stabilization is a marathon, not a sprint. We also have to look at the social circle reset. As we discussed in the previous section, the social network often fractures during a divorce. In the reconstruction phase, Kevin must become a social engineer. This involves the vetting of his tribe. He must distinguish between the friends who are merely observers of his trauma and those who are catalysts for his growth. Sociological data suggests that men who join mission-driven organizations, whether professional groups, fitness communities, or civic organizations, recover their sense of purpose faster than those who attempt to navigate recovery alone. The goal is to build a support network that is not based on his status as a divorced man, but on his interests and values as an individual. Then there is the concept of post-traumatic growth, or PTG. This is a recognized psychological phenomenon where individuals experience positive psychological change as a result of struggling with highly challenging life circumstances. For Kevin, PTG manifests as a shift in perspective. He begins to see the dissolution of his marriage not just as a loss, but as a shedding of a dysfunctional system. He gains a level of emotional intelligence and resilience that he never would have developed in a stable, albeit mediocre, marriage. Case studies of men who have reached this stage show an increased appreciation for life, a deeper sense of personal strength, and a more robust spiritual or philosophical grounding. This is the turning point where the man moves from being a victim of the legal system to being the architect of his own future. Step by step, the reconstruction involves a meticulous audit of one's habits. Kevin must address the physiological impact of the divorce. This means prioritizing sleep, nutrition, and physical activity to clear the remaining cortisol from his system. It means seeking out cognitive behavioral tools to break the cycle of ruminating on the past. In the social studies of 2026, we see that men who treat their recovery with the same professional discipline they apply to their careers have the most sustainable outcomes. They are the ones who eventually look back on the divorce as the catalyst for a life that is more authentic and more disciplined than the one they left behind. But even as Kevin rebuilds, a final question remains. How does he ensure that he never finds himself in this position again? In a world where the social contract of marriage is increasingly volatile, and the legal system remains a complex machine, how does the modern man future-proof his life? How does he approach new relationships, new contracts, and new social structures with his eyes wide open? In Part 10, the final chapter of this masterclass, we are going to synthesize everything we have learned into the ultimate survival blueprint. We will look at the sociological trends of the next decade, the evolution of prenuptial and cohabitation agreements, and the philosophy of the new autonomous man. We have navigated the history, the law, and the recovery. Now it is time to build the fortress. Stay with us for the conclusion of the deep dive. The conclusion of this masterclass is not an endpoint but a transformation into what sociologists in 2026 are calling the new autonomous man. We have spent 9 parts deconstructing the machinery of the American divorce system, from its historical roots in fault-based litigation to the digital dragnets of modern discovery, and the complex psychological recovery of the post-judgment era. Now we must synthesize this knowledge into a proactive blueprint for life in the mid-2020s. The goal is the creation of a personal fortress, not one built of walls to keep the world out, but one built of informed agency to ensure that any future domestic contract is entered into with total transparency and risk awareness. Imagine Thomas, a 52-year-old architectural consultant in Denver, Colorado, in December 2026. Thomas has successfully navigated the reconstruction phase we discussed in Part 9. He has stabilized his finances, secured his relationship with his children, and rebuilt his professional reputation. Now he finds himself at a sociological crossroads. He has met someone new, and the relationship is progressing toward cohabitation. In the social studies of 2026, this is a high-stakes transition. Historical trends indicate that many men who have survived a primary divorce often fall into the same structural traps in their second or third significant relationships because they rely on hope rather than data. The first pillar of the new autonomous man's fortress is the understanding of the default state contract. In the United States, if you do not create your own private contract for a relationship, the state provides one for you. This default contract is governed by the very statutes we have dissected throughout this series. Thomas realizes that in 2026, simply moving a partner into his home can trigger legal complexities. In several jurisdictions, the concept of commitment ceremonies or long-term cohabitation can lead to palimony claims or the equitable distribution of assets acquired during the cohabitation period. To mitigate this, the sociological trend among informed men is the use of cohabitation agreements. This is a step-by-step process where both parties explicitly define the financial terms of their shared living arrangement. For Thomas, this means a document that clarifies that his home, which he worked so hard to retain during his divorce, remains his separate property. It specifies how household expenses are shared and, crucially, it waives any future claims to support or asset division should the relationship end. This is not about a lack of trust. It is about the social study of clarity. Potential outcomes for men who utilize these agreements include a significantly reduced risk of secondary litigation and a more honest, transparent foundation for the relationship. Next, we must examine the evolution of the prenuptial agreement in the 2026 social landscape. For the new autonomous man, a prenuptial agreement is no longer seen as a divorce insurance policy, but as a marital business plan. Historical trends show that marriages where financial expectations and asset divisions are pre-negotiated often report lower levels of daily conflict. Thomas understands that a modern prenup must be robust. It must involve full financial disclosure, independent legal counsel for both parties, and it must be signed well in advance of any wedding date to avoid claims of duress. Step by step, he documents his premarital assets, including his retirement accounts, his business interests, and his intellectual property. By doing so, he is preventing the future commingling or transmutation of these assets into marital property. Consider the case study of transmutation in 2026. Imagine if Thomas uses a portion of his separate, post-divorce savings to pay for a renovation on a house he buys with his new partner. Without a clear contract, the law may view that separate money as a gift to the marriage, effectively turning his private capital into a shared asset. The social studies of family law are littered with men who lost their reconstruction capital because they did not understand the mechanics of how separate property becomes marital property through simple actions. The new autonomous man maintains strict account segregation. He keeps his premarital inheritance or savings in accounts that are never touched by marital funds, ensuring a clear paper trail that can withstand the discovery process we covered in Part 4. The third pillar is the mastery of social and digital sovereignty. As we saw in Part 8, the digital world is a permanent archive. Thomas now operates with a public record mindset. He understands that every text, every email, and every social media interaction is a potential exhibit in a future legal proceeding. This does not mean living in fear. It means living with discipline. He utilizes encrypted communication for sensitive financial discussions and maintains a curated digital footprint that reflects his professional values. Sociologically, this creates a shield of credibility. If he is ever again subjected to a character assessment in a courtroom, his consistent, disciplined history serves as his best defense. Furthermore, the new autonomous man embraces the philosophy of life cycle financial planning. In the social studies of 2026, we see a move away from the joint everything model. Instead, men are opting for proportional contribution models where each partner contributes to a joint household account based on their income, while maintaining separate personal accounts for their own investments and legacies. This model aligns with the modern social shift toward individual autonomy within a partnership. It ensures that if the relationship dissolves, the unwinding process is administrative rather than combative. We must also address the psychological fortress. This is the internal resilience Thomas has built through the trial and reconstruction phases. He has moved from the provider-protector trap, where his entire worth was tied to the domestic unit, to a state of internal validation. He understands that his value as a father and a man is not determined by a court order or a support calculation. This psychological shift is the most powerful deterrent against the emotional manipulation often found in high-conflict cases. When a man no longer fears the loss of his identity, he becomes a much more effective negotiator and a more stable parent. Step by step, the journey through this masterclass has taken us from the historical shifts of the 1970s to the high-tech, high-stakes reality of 2026. We have looked at the financial traps of the first 30 days, the sociological warfare of the custody battle, the digital dragnet of discovery, the pressure cooker of mediation, and the clinical theater of the trial. We have analyzed the enforcement power of the state and the destruction of social capital. Finally, we have mapped out the reconstruction of the self and the building of a future-proof fortress. The potential outcomes for a man who has completed this deep dive are profound. He is no longer a passive participant in a system he does not understand. He is an educated, strategic, and autonomous individual. He recognizes that the American social study of divorce is not just a legal process, but a profound reflection of our evolving social contract. By understanding the rules, he has gained the power to navigate them, and by understanding the history, he has gained the wisdom to avoid repeating it. This concludes our 10-part deep dive masterclass, Divorce for Men in American Social Studies. However, the application of this knowledge is a lifelong process. The social landscape of the United States continues to shift, and new challenges in family law, digital privacy, and economic policy emerge every year. What happens when the next wave of legislative changes hits the family court system in late 2026? How will the rise of AI-driven judicial assistance change the nature of legal strategy? The fortress you have built today must be maintained for tomorrow. Our next series will explore the emerging social contracts of the 2030s and how the definitions of family and property are being rewritten as we speak. The education continues. The autonomy is yours. See you in the next deep dive.